Our hashtag is Newsdesk. Now we go straight to a top story. These are coming from the corridors of justice, and Naivasha Member of Parliament Jane Kihara, who was arrested yesterday by Directorate of Criminal Investigations officers after she declined to honor summons for alleged incitement, has been arraigned at the Milimani Law Court. Kihara was whisked from her home in Maraigushu to Naivasha police station, where she denied allegations of being behind the chaos in Naivasha that saw several traders lose their property to hired goons. In her defense, the lawmaker accused the state of intimidation. The MP was held at basement cells awaiting her presentation in court. Earlier, there was cat and mouse games as the MP was whisked away from the court's parking lot after the DPP allegedly declined to approve criminal charges against her. She was returned by the DCI detectives to the Milimani Law Courts after an hour. We now cross over live to the courts and follow that matter as it continues in the court.
The arguments, other than being based on sections 89 and section 134 of the Criminal Procedure Code, also is founded on a conflation of the criminal law vis-a-vis constitutional law of Kenya, and which needs some unpacking, a little bit of unpacking. And I'll say again that Mr. Ndegwa has done so well in his arguments on the constitutional perspective, which then I start with. But Your Honor, for all of us, any court can only do as much as they are provided to do in terms of jurisdiction. Without jurisdiction, a court downs its tools, in which case you will down your blue pen if you are asked to do something outside your jurisdiction. As correctly noted by Mr. Ndegwa, the jurisdiction of the Magistrates Court to hear and determine criminal cases is provided for under Section 8, the jurisdiction of this court to hear and determine questions of alleged violation of the Constitution or of Bill of Rights is provided for under Section 8. Interestingly, I was listening so keenly, my learned colleague goes to Section 3, Section 4, then he gets to 8 and tells you Section 8.1. I want to read 8.1, which he referred to, if you permit me. I can go to another as they look for it for me, because it seems it's not in my bundle. My colleague is assisting me with it. But in a sense, what it says from the reading as we wait for the actual text is that the magistracy have the power to interpret and apply the Constitution. Yes, correct. Thank you, sir. 8.1, claims relating to violation of human rights. That subject to Article 165(3)(b), which I'll come to shortly, of the Constitution, and pecuniary limitations set out in Section 7.1, a magistrate's court shall have jurisdiction to hear and determine applications. Hear and determine applications for redress of a denial, violation, or infringement of, or threat to right or fundamental freedom in the Bill of Rights. He does excellently well by bringing that out. But he leaves 8.2. Let's go to 8.2. The applications contemplated in subsection 1 shall only relate to the rights guaranteed in Article 25A and B of the Constitution. He deliberately ignored it because we've had this discussion. So that if there were allegations, if their arguments are based on alleged violations of rights or of the Bill of Rights or any provision of the Constitution, if they went outside Article 25A and B, this court must drop its pen in respect of all the other provisions of the Constitution. And that will include Article 10, Article 19, Article 20, Article 21, and Article 27, and 33. But I'll address 33 again shortly. Because you do not have jurisdiction to hear allegations of discriminatory charges, if at all, if that's what they are saying. You would love to, but the Constitution says no. Another fundamental and a very beautiful argument that my learned colleague has made today was in his element, is that Section 94 was enacted on the first, became effective on 1st of August 1930. I must confess I didn't know, but I believe him. He's a good man. But he then gives the response and says there is Section 7 of Schedule 6, and it tells us what it says, that if there was a law existing before this constitution, then read it with the necessary adoption, alteration, or amendments to bring it into conformity with this constitution. So that answers the most difficult question he raised. Can we apply a law that was enacted in 1980 today? The answer is yes.
That is the matter regarding the arrested MP that is being prosecuted in court. We shall be heading back there a little bit later as the matter continues. But now to another shocking story. And